Commercial Leases, and my name is Jamie Heiberger. I want to cover a couple of important things that are changes that have taken place over the last couple of years so that we have a basic knowledge as to what we're looking for in commercial leasing and how it might be different than it was previously, because there's many of you out there that you might have leases that have been ongoing for some 10 years now, and provisions in there that may have protected you in the past are not going to be protecting you going forward. Now, commercial and residential, the biggest difference that we see right now these days is just how much the rent laws have changed in New York. And obviously it's still different for commercial than it is for residential, given good cause eviction and the other many other changes that we've seen over the last couple of years even. When we're dealing with residential, there are certain representations and must-haves that must exist in every single lease as opposed to commercial. One of those big examples is the fact that in a residential setting, there are certain building requirements that you cannot get past. Unlike in a commercial setting, you can contract almost any obligation either way. Best example of that might be in a residential deal, you're not going to be able to rent an apartment or a house for somebody to live in. You're not going to be able to sell it for them to live in unless it meets certain requirements, and those requirements can get waived in a commercial setting. So what are the key things and what are the most important points that we want to look at? Well, we're always starting off with an LOI, a letter of intent. You generally are not going to have that on your residential deals, but on your commercial deals, you are going to have that. And generally speaking, the brokers are going to come together and they're going to put the terms that everybody has agreed to. But that doesn't mean that those are the final points, because oftentimes there are just points overlooked. And so it's really important that if you're the owner, that when your brokers come to you and they give you your term sheets, that you want to make sure that either yourself or your attorney identifies what might be missing, the key points here. One of the, just a couple of, just right off the bat, you're doing a commercial lease and you want to make sure you know what can the property be used for. And in order to find out what a property could be used for, as many of you know, you would be checking, depending upon where the property is located, you're going to check the building department in that county or municipality. And generally speaking, you're going to be able to find the use there if there's a certificate of occupancy. In areas where they do not, either they don't keep the certificates of occupancy on file or it's a different format, whatever that format is that identifies the use. Remember, prior to 1939, certificates of occupancy did not exist. So there was a different manner with which the use of a property was identified. And in New York, like in the city, the boroughs, those are the I cards. The I cards identify the use of a property. And the reason why I bring that up as one of the first things that we want to look at is because it's the use that's going to be one of those points that often and generally gets put onto the occupant. So the commercial tenant who rents a space and plans on having it as a hair salon, it is incumbent upon them to comply with their licensing and whatever other requirements might be needed for their use. And so one of the things, and I'll give you an example. I actually have a really good, an unfortunate example. I had a client come to me many years ago. Well, not many, a couple of years ago. And she had come, I think she was already living in New York, but it was very much sounded like a scenario of my cousin moved here and brought all her money, and her and the ex-husband were opening up a restaurant, and they signed the lease, and they couldn't even use it as a restaurant without performing all kinds of work. Now, of course, the first thing that I ask when they come to me is, did you have an attorney when you signed the lease? And the answer was yes. And so right away I said, look, you had an attorney representing you when you negotiated the lease terms, and when you executed the lease, you don't have a leg to stand on to say that the landlord did something wrong. And then she went on to say, well, they represented, it was misrepresented. Anyway, in any event, I said, look, I don't really know what I'm going to be able to do for you. Probably not much. But I will say, and this is the unfortunate reality, when cases are commenced, regardless of which side you're on, are you the landlord or are you the tenant? No matter how wrong one side is, it doesn't mean that things don't get worked out. Now, the fact that my client expected there to be proper venting and a proper grease trap and everything else that would have been needed so that they can go and operate the restaurant, they should have known all of this before. They should have asked those questions. Presumably their attorney would have, but didn't. And I explained that there's not any right to any of this, but we will try our best. Anyway, so far it's been a huge challenge, and unfortunately, I don't think that they're going to have any basis whatsoever to get any relief, but because the other side is not willing to settle it. And so that brings me to another key point. If you're going to issue a lease, a commercial lease, and your tenant's name is a corporation, an LLC, any form other than an individual, if it's an entity, the tenant cannot represent themselves. And I know I have seen leases done in corporate names with tenants without lawyers, and that is just not a valid lease. So you want to be really careful there. If your tenant wants it to be in a corporate name, then they must have a lawyer. If your lease is done in the tenant's individual name, then they don't have to have a lawyer. I personally prefer dealing with lawyers on both sides because I don't ever want to hear from somebody that they were not properly advised or they didn't understand. My English wasn't that great. And that was my case also. My client, her English wasn't great, but I was speaking to her representative the whole time and she was always involved. Unlike residential, commercial leases, you could rent a space with nothing. You could rent it without power. You could rent it without any services whatsoever. But however it's going to be rented, you want to identify those terms in your LOI every time. And what is it that we really want to know here? Well, first of all, we want to know how we're paying rent. If, depending upon where the space is located, it may very well be a flat price. But one thing you have to be careful of is when you see a price for a commercial property and it's based upon the square footage. And the reason being, if they just say like, okay, it's $50 a foot. Well, unfortunately, most properties in New York, in the city especially, any building, anytime you're in a building, not just the city, but in a building, because of the elevators, the stairwells, there's a huge loss factor. And so you end up paying for square footage that you don't have use of. So a lot of times people just want to know that it's like that, straight flat number. So that's one thing, how are you going to be paying and what's going to be included? With commercial properties, oftentimes there are additional charges, which are called CAM. CAM is the acronym, and that's Common Area Maintenance. So there are common area maintenance charges that get allocated to the different commercial tenants in the building. If it's a taxpayer and it's one, then maybe they're paying a part with the owner. Maybe they're splitting that. If it's a building that has more than one commercial property, then it will be each tenant's going to be notified as to what their piece is, how much they have to pay on cam, no different than paying real estate taxes. Now, one thing that is very common in most commercial leases these days, not smaller leases, if you're a landlord that has, building, a small office building or commercial building, you might not have those cam charges. The larger ones you definitely do. And basically, what we want to make sure of, how are we getting the space? We know what the charges are going to be. How's it going to be delivered? One of the problems that does happen oftentimes in a commercial space is if a tenant is taking a space and they're going to build it out themselves, it might take time before they can actually occupy and conduct business. And under those circumstances, oftentimes, a tenant will request free time, or maybe an owner will offer it. Generally speaking, if an owner is doing the build out themselves for the tenant, then it's obviously they can't be paying rent while it's getting built out. But also, if the tenant's building it out themselves, they're not going to be able to occupy. So generally, that's where we talk about our free time. And that free time is not necessarily, is it free time because you're not operating the business? It's generally free time to allow for the renovations work to be completed, signed off, whatever needs to happen. Now, most commercial leases, I would say, are not done in an individual's personal name, but instead they are done in a corporate name. And then there will be either a personal guarantee or a good guy clause. Personal guarantees and good guy clauses are extremely commonplace on all commercial leases. Very, very, very rarely will you find a commercial lease that does not require, at the very least, a guarantor. And if it's not a personal guarantor, then maybe it's just a big corporation and the corporate guarantor actually is a viable entity, and therefore they might take a corporate entity as the guarantor on a good guy clause. So now you say, what is the difference between a good guy guarantee and a regular guarantee, a personal guarantee? Well, the difference is that a personal guarantee is guaranteeing the entire balance of the lease. So in a commercial setting where you don't have the duty to mitigate the way that you do in a residential, though you really do also, but forget that for now. You want to make sure that you get enough time either way. So if the tenant's going to be the one that is going to be paying it, you just want to make sure that they have enough time to do their work. But on the landlord side, what I wanted to get to was that if an owner's not collecting rent and an owner's paying for the build out, or the owner's paying for it, tenant's doing work, whatever the circumstances are, the owner of the property is going to be giving up rent to allow the tenant the time to get situated so that they can they can operate their business from the location. Now, what happens if the tenant only has a good guy guarantee? Stay with that for a second, because we're going back to this. So now the good guy, the personal guarantee is they're promising everything through the lease expiration, as opposed to a good guy guarantee, which is basically stating that I, good guy guarantor, will guarantee payment through the time that I vacate the premises in accordance with the terms of the good guy guarantee and give the keys to the owner. Most good guy guarantees have at least a 90-day requirement of notice. 120-day requirement is also very common, 60 much less. It really depends upon how long the lease is. So in those situations where you have a good guy guarantee, it's going to take some time before the owner is going to make up for either the lost rent that they didn't get during the renovation period, or the cost to renovate and the rent. Could be both. And so generally speaking, if you're going to, let's say you're an owner and you're doing a 10-year lease for somebody and you're negotiating the build out and you're not going to be collecting rent for a certain period of time, I always make sure for my clients in those situations that the good guy guarantee will have a carve out. Because what you don't want is you don't want somebody to come in there with a new business. You, the owner, build out the space. Now the tenant moves in, and 3 months into it, the tenant, they just can't succeed and they want to bail. Now what? Do they get out of the lease? Hell no. What you want to do under those circumstances is there has to be some sort of a negotiated time period so that if the tenant were to try and vacate within the first year, within the first 2 years, it all depends upon how much you, owner, gave up for the tenant during this time period. So what is it going to mean? It's going to mean, well, how many months didn't you collect rent, or how much money did you spend versus how much you collected prior to them now taking off and wanting to cancel the lease. So you do want to make sure that that gets addressed. Very common in commercial space, where when you're reviewing a commercial lease, it's not uncommon that instead of the tenant just paying Con Edison directly, oftentimes the way that bigger buildings will work is that the electric is provided to the whole building, and the owner of the building has there's a middleman in there and they're providing the power, and then there's a bill there, and then the owner bills out to their subtenants, and there's usually a little bit of an upcharge on it, whether it's 4% or 9% or 11%. Always try and negotiate that because you usually can. With commercial leases, I'm in favor in New York of, if you're in one of the boroughs, of course, the REBNY forms. I do commercial leases. I've had clients call me that are doing a lease up in Sullivan County. Obviously, it's different. It's not New York City, and oftentimes they're also using those leases up there that the brokers are still doing, even though brokers aren't supposed to do leases. I do find in the smaller municipalities that still does go on. But a REBNY lease, I can tell you right now, it might not have something that's an obscure requirement of the location that the property is in, but for the most part, if you were to go through a REBNY commercial lease, it's going to cover just about every topic that you want covered. And I'll pull one up in a couple of minutes. Now, let's talk about it from the tenant side. Tenant's going to go in and rent a space. You're going to get a commercial space. What are your requirements going to be? Well, let's just say hypothetically that the space can be zoned as a restaurant, but it has never been used as a restaurant. So now there's going to be a lot of changes that are going to have to be made because there's going to be cooking done there. So there's going to be an exhaust. We're going to have to deal with grease traps. There could be an issue at some point in time with the plumbing and going to the main sewer line. And what if something that gets caught there interferes with it? Whose responsibility is that main sewer line going to be? And I always try in those situations, we want to make sure that the tenant would be responsible for anything that they're connecting. If they're using it, they're responsible for it. It's not uncommon that a property will get delivered to a tenant in what's called a vanilla box. And that's just what it sounds like. So basically you might have plumbing capped off to the property. You might have the electric capped off to the property. Generally speaking, most businesses, the electric is sub-metered. And so each tenant is paying whatever theirs is, plus whatever that upcharge is, if the owner is the one in charge of providing the power. If we're talking about as the tenant going into a space, my biggest worries are, is this space ADA compliant? And am I going to have to make it ADA compliant? That's a big one, right? Because if you're the tenant coming in there and this is an older building and you're open to the public, you have to make sure that everybody coming in there, that the doorways and the hallways are ADA compliant, that there's a proper means of egress that's ADA compliant. The bathrooms, you have to be able to get a wheelchair underneath the sink. And so a bar in there, the width of the door there for the bathroom. So that's a key thing is it ADA compliant? Is all of the fire safety connected? Is it already there, or is my client going to be required to put in their own fire suppression system and alarm system and connect it to the city? We want to make sure that we understand what utilities are already at the building. Are they provided and accessible to the tenant's space? And how are the charges allocated? So in other words, we might have, as I said, with the electric, you're going to have a sub-meter on it. Most of the time, most of my clients will have the meters read by a meter reading company monthly, and then they'll just bill their tenants. One thing you have to keep in mind when it comes to the city billing, it's generally goes months at a time. So sometimes we need to just wait a couple of months so we know exactly what the charges are going to be. As far as real estate taxes are concerned, generally speaking, owners charge tenants the increase in the real estate taxes from the time they came into possession, from the time of their lease, compared to a certain base year. For example, I took my first space in 1996 when I opened my first law firm. My real estate tax base was 1995 to 1996. I ended up leaving that space and moving to my next office when that was probably, I would say it was about 15 years later, 10 years later. By the time I left, my taxes were more than my rent. So I had to leave. My real estate tax base was so low. I mean, that was just different world, different times. On a year-to-year level, we don't see those kind of changes, but when we start looking historically as changes happen, those numbers can be quite significant. So most people that, depending upon what's going on economically in society and what we're hearing as far as taxes go, might dictate the direction that either how an owner wants to charge or how a tenant wants to pay. Owners may very well file for reductions of taxes. So if you're a tenant coming in there and the owner files, you may want to request in your lease that if the owner's taxes are reduced, that you're going to get your proportionate share reduced. In a commercial lease, you always want to know what the responsibilities of each of the parties are going to be. Now, while a commercial tenant will generally be responsible to maintain the property themselves, in a situation where the commercial space has others above them, then you do need to be careful to make sure that you, the tenant, if you're representing a tenant, that they're not going to be responsible if the tenant above them floods them out. So we just want to be careful there. Now, if this was a tax credit and there was nothing above, then certainly we may expect that it would be the tenant's responsibility. But if I was the lawyer for the tenant, instead, I would actually be stating that, hey, it's your roof. Your client owns the building. If my client's space gets water because the roof leaked, then that should be on the owner to repair it. And these are just all, of course, negotiated points. Now, we were talking about guarantees, and there's the guarantee law changed very recently, and this is probably the biggest risk that you owner would have if you're operating off of an old lease and you're doing a renewal lease. I would be careful when it comes to the guarantee language, because these days, unless the guarantee specifically states exactly what is going to happen at the time of a renewal, saying that it renews anyway is not going to be enough of the language. What happens is you actually have to state that if the tenant renews the lease, this guarantee shall be a part of that renewal lease and shall remain in full force and effect. You have to write the whole thing. If you don't, you might not be covered on the guarantee against the tenant at the time of renewal. That was a big change. As a tenant, you want to make sure that you have the right to seek what's called injunctive relief. And if you're the owner, you want to prevent the tenant from bringing an action for injunctive relief. So what does that mean? Well, let's just say that the owner is complaining about the tenant because the tenant keeps leaving their garbage in the vestibule area instead of where they're supposed to leave the garbage. And the owner has a camera and they keep seeing it, and they now serve the tenant with a notice, and that would be a notice to cure. Stop that conduct or we're going to terminate your lease. If the lease doesn't prevent the tenant from seeking an injunction, then the tenant, after getting a notice to cure, should run into Supreme Court, hire a lawyer, going to Supreme Court to bring an action, which is asking for a stay preventing the owner from terminating the lease. And that happens a lot. It could be, there's so many different reasons this goes on. I have a commercial case where we got served because my client hadn't opened, and what happened was there was a whole delay with the liquor license that they were getting, and even though we were late on it because they gave us the notice after it had already expired, generally speaking, as long as they didn't serve that termination notice yet, the court is going to be in favor of giving the tenant the opportunity, the tenant that's invested in this, they have their business there. They're not going to just give them no chance just because they were a little late on it. However, once it's terminated, it could be a problem if somebody really fought that hard. Now, what happens after occupancy when the fire department mandates the tenant installs a sprinkler system and it was not required prior? That's a really tough one because the laws have changed in terms of when sprinklers were required. Now, if a building was built prior to the time that sprinklers were required, then it doesn't have to have sprinklers. If a building was built when sprinklers were required, it needs sprinklers. If somebody were to go and rent a commercial space now, that's a huge factor. You need to make sure that if it needs sprinklers, that they get put in. And the other problem that you have sometimes, like I know I'm looking at my office right now, and my office, I don't have any offices all the way to the ceiling. They're like half walls. You could see it right there. That's my office, and it goes around, because if I went all the way up, then I was going to have to add sprinklers here. I do have sprinklers back there where the ceiling's really high, but in other words, once you make certain changes, then your compliance requirements change as well, which actually brings me to the ADA issue. Take, for example, a property that is not ADA compliant. A building, a townhouse style building, whether it's 10 apartments or it's a single family, irrelevant. One of the reasons why, when you go down these tree-lined streets, besides the fact that they're beautiful, but that the facades of so many of them are redone, maintained, not actually taken down and changed. And that's also because once you demo the front of a building, now you're going to have to build that building ADA compliant. Anything that is a new law that comes into effect, not everything gets grandfathered in, but most things do. It's definitely a situation, and I think in the context, more so in the context of commercial. So if you have a commercial tenant in there, and now when they first went in, like you're asking, they weren't required, and then the mandate changes and it is required, well, the owner can't possibly make the tenant do that, when even though the problem you run into, because I'm kind of talking both ways now, because most commercial leases and most leases in general do provide that if it goes against public policy, it wouldn't be enforceable. Now, in the situation like this, I think that it would probably get put on the owner, not on the tenant, probably be a negotiated thing. I remember when this first happened in, like, I want to say 2014, but I don't know why that's the year that's coming to mind for me. I feel like that's when maybe the sprinkler laws changed. It's been an issue. I don't know how people have solved it necessarily, but it's definitely been an issue. I want to show you guys, I'm going to pull up a commercial lease form for you. I just want, for those of you, I don't know how many people have looked at them or don't even know what one looks like. So I'm just going to pull one up here for you and just quickly go through it. Now, keep in mind that the commercial lease form that I was telling you about, the REBNY form itself, it happens to really be a very comprehensive document. Rider, a lot of times you'll see rider provisions that really say a lot of the same stuff as the printed form. Doesn't really change it, but if it does change it, then the rider prevails. Riders always prevail over the printed form. Now, the first one I'm going to show you is an office lease form, and this is a REBNY lease form. Just so everyone's aware, and I know that there are people that just take the REBNY lease and make copies of it. It's not legal to do that. These are copyrighted forms, and so we always do them in draft, and then we just buy a new form to do our final one when our clients agree on the terms. So pretty much, lease forms are fairly standard. It talks about who does the alterations, who does the maintenance, window cleaning, legal requirements, subordination. What does subordination means? It means that if there's a mortgage on the property, that the lease is going to be subordinate to that mortgage. Property loss. An owner will always, well, I shouldn't say always. Generally speaking, owners require that their tenants get their own insurance. That insurance is to protect against the tenant's personal property, of course. The owner, as owner of the building, would need insurance for the replacement of the building. And you always want to have your tenant add the management company, if you have one, as an additional insured as well. Oftentimes, I like to tell my clients, whether you're the owner or the tenant, I like insurance provisions to go over to the insurance brokers. I never want to take any chances that there wasn't some other requirement that we didn't know about, that my client didn't know about. And so I like to just make sure. Eminent domain, it's happened. I have clients it's happened to. The city can come in, pay you money and tell you to get out. Assignment. Now, assignment and subletting in commercial, you can negotiate and contract whatever you want. Unlike in residential, where you cannot prevent people from assigning or subletting because property has to be freely traded, is the theory. Electric, it's addressed in the rider. Access. Sometimes owners of commercial property might need to access part of the tenant's commercial space. This is where, now, paragraph 15, that is the one that I was referring to before when I said, generally speaking, a tenant of a commercial property is going to be taking the property as is. That paragraph 15, if an owner says nothing in the rider and nothing is anywhere else, this obligates a tenant to take this space and be responsible for their use to comply with what's allowed at the property. And if it doesn't, it's on the tenant to have to file to be able to use the property in compliance with, the applicable zoning and use provisions. Bankruptcy. When a tenant, residential or commercial, files for bankruptcy, there is going to be an automatic stay. But what's a little bit easier than residential, with commercial, at least you can go and terminate the lease if it's not going to be covered. Now, these are just your basic standard lease provisions. There is this guarantee. Generally, I don't use this, but some people do. There's a guarantee on there. That's not a good guy guarantee. That's just a basic guarantee. Now, as far as the rider forms are concerned, there's so many different riders that owners use for commercial leases. I don't know that there's necessarily a standard one, but I would say that 95%, they should be pretty much the same. We're not reinventing the wheel. What you really need to do, though, is understand what's needed for your deal. In other words, does this particular property, maybe it's just building heat. Maybe there isn't separate heat for the commercial space. Is there, it comes with cold water. Maybe the tenant only has to pay for hot water. So they would maybe have to have their own hot water heater. If a commercial tenant's use is going to require equipment, most of you on here are brokers, many of you on here are brokers, you certainly want to make sure that, say, for example, your client's going to be putting in an HVAC system. Where are they going to keep the condensers and the fan? Where is that going to go? If you're in a high-rise building, you need to know before your tenant goes in there, where is the equipment going to be? Is it going to be on the roof? Are you going to have access to it? Is there a system in place? HVAC is a big one because, generally speaking, commercial leases will put the obligations for the HVAC onto a tenant. And if that's the case, I always tell my client, make certain that you do not use that space at all until you have an HVAC maintenance contract in place. Obviously, a tenant shouldn't be responsible to replace equipment, but the tenants are generally responsible to repair it. And so I think it's very important to put certain specific language in there when it comes to the HVAC. And I think that the easiest way for most commercial tenants is to get a maintenance contract in effect. Depending upon how big the building is and how the building is run, it's not uncommon that AC or heat, for that matter, are only on at certain times of the day. So maybe if it's going to have to stay on later, oftentimes a lease, especially for a bigger building, is going to provide in that lease that the tenant's going to actually pay to have it on later. Otherwise, you could hear at 6 o'clock at night, all of a sudden you could hear the vents and everything shuts down. And that's quite common when you're talking about larger buildings. Commercial leases will also allow for multiple months of security deposits. Unlike residential, where you can only have 1 month's security in advance, commercial is different. You could require as many months as you'd like. You can use a letter of credit, either way. And generally what will happen is the security and the first month's rent, the multiple months security, are going to be due in advance. It's not uncommon. Let's just say you have a situation where the owner wants 6 months rent as security. In those circumstances, if your client has a real beef with it, just put something into the lease that allows for your client to get 1 or 2 months of the security back, provided that they remain compliant for the first, whatever it is, 2 years of the lease. When it comes to commercial, unlike residential, we always put our legal fees, we always put our late fees. You can collect both of them. It's different. Now, that's not to say that if two parties go to trial, an owner sues a tenant, now they're in court. The tenant can make the owner prove their case and make a motion for legal fees in order to entitle them to it. But practically speaking, in commercial cases, we do charge it, and the tenants generally do pay it. The process, unfortunately, I wish I can say that commercial cases moved much faster. They do move faster, but it doesn't, not necessarily all the time, and not necessarily do they move that much faster. And so it doesn't, unfortunately. I wish that I can say that we could speed through it. It's not, it's really still not like that. It's still the landlord tenant part of the civil court. And as in those cases just do seem to take much longer now. They do move faster. You can definitely push them faster, and you can definitely move for all of your extras on it. A commercial lease, generally speaking, will have increases in rent based upon percentages. And if it's going to be renewed, generally speaking, a tenant will want to account for what the increases will be at the time of renewal. A tenant that wants the option to renew their lease, generally speaking, the clauses in the lease are going to provide for certain conditions that the tenant is allowed to renew the lease as long as they remain compliant during the term, or definitely at the moment that it's time to renew the lease. In a commercial matter, you have to comply with whatever the notice provisions are that are contracted to between the parties. If you're a big landlord, I always recommend to keep consistency, because what happens is you start doing these leases, and then all of a sudden you have a tenant's attorney that's saying to you that wants, well, I want 30 days on this. Yeah, you can do it. But if you're somebody that has, 300 commercial properties, and if you have everybody on under different default provisions, it will get very hard to manage it. So I like to try and keep things consistent so that we don't run into that problem. As far as suing somebody for their lease and whether or not they can be held liable to it when they can't occupy, that brings us to a very big point of contention when we're dealing with commercial leases, which is the concept of force majeure. Force majeure really never got anyone anywhere. A little bit after 9/11, a little bit by the financial crisis, and hugely from COVID. Why? Because if you were in occupancy during, it was like 2020 to 2021 or 2022, there was a very strong limitations on the ability to go after those that part of the business, at least they needed to still be in their space, let's say. But if they couldn't be, and now the law changed recently, because previously you couldn't go after the guarantors. Now, recently a case just came out that those guarantors would still be responsible. So always a tricky thing doing the guarantees. As far as force majeure, I don't put in force majeure language anymore. There's no more COVID stuff. I think that most people are concerned, should there ever be a government shutdown, that they're not allowed to occupy their space, that they shouldn't be obligated to pay rent. Tenants, of course, try and get that in there. Owners, of course, try and keep it away. So it's all a negotiation. It really is. Let me see if there's any more questions. How does the commission payout generally work for commercial leasing? Great question. Again, negotiation. I think that the negotiation on how commercial gets paid has definitely changed over the years, especially because there was not a lot of commercial business going on. And so certainly people were anxious to get their fees. Generally speaking, the way that it works is it depends. I know that the bigger commercial companies, your CBREs and JLLs, whatever, I think that those companies do get paid each year. I don't think that they get paid it all up front. I think they get paid at the original, and then they get paid at the renewal. Again, it's all negotiated. If you have any other questions, or you have a commercial, one of the things that I tend to find myself do very well is I'm very good at figuring out what to do. So there might be something that comes up in one of your leases and you just don't know how to get past it. That's where I definitely really shine there. So anybody has any questions, please reach out to me. Otherwise, have yourself a great rest of the day. Talk to you soon.